Our next panel today is going to be talking about the legal aspects of token issuance and trading. Moderating this panel will be Dan Zelenko, who is a partner at Crowell Mooring and also is the chair of their White Collar and Regulatory Enforcement Group. In addition, he's a former federal prosecutor and was a senior enforcement officer at the SEC. Don't worry, he doesn't bite. Would you all please join me in welcoming Dan and our panelists to the stage.
Morning, everybody. As Marc said, my name is Dan Zelenko from Crowell Mooring. Some people ask me what I do for a living, and the explanation that's probably easiest for people to understand is that I represent misunderstood capitalists. So I think I'm in the right place today. Let me introduce our incredible panel today. Kristen Howell is a partner at Fox Rothschild in Seattle. She spent over 20 years advising issuers, public and private entities on corporate securities and financial services matters. She currently focuses on token securities offerings, Reg A+, and blockchain and technology-related private equity funds. To Kristen's left is Marc Boiron. He's a partner in the fintech and blockchain practice at FisherBroyles. He represents leaders in digital ledger technology and digital currencies that operate businesses in a broad number of industries. He advises on ICOs, STOs, smart contracts, crypto funds, and other cryptocurrencies. Thanks for being here, Marc. To Marc's left is Ralph Daiuto. Ralph is, as many of you know in the audience, is the COO of tZERO, a fintech subsidiary of Overstock.com. tZERO is really a pioneer of blockchain technology and is really an important player in the space. Ralph also serves as the president of two broker-dealer subsidiaries, Speedroot LLC and Pro Securities. Ralph, thank you very much for being with us today. And finally, to Ralph's left is Stephen Obie. Steve is a partner at Jones Day Law Firm in New York City. Before joining Jones Day in 2014, Steve was the director of enforcement for the CFTC in both Washington, D.C. and New York offices. So thanks very much, everybody, for being with us. Let me start with Ralph. Ralph, I know this has been a pretty interesting week for you at tZERO. Maybe you can explain a little bit about that. But really, I think for the audience, as somebody on the issuer side who's been in this business for a couple of years, if you can kind of take us through what has tZERO done and how have you done it?
Sure. So at tZERO, and for those who don't know, right, and I think as Dan pointed out, we are a majority-owned subsidiary of Overstock.com. Overstock was the first large e-commerce retailer to accept Bitcoin as a currency, but for Dr. Byrne, it wasn't about Bitcoin, it was really about the underlying blockchain technology. One of the use cases that Patrick saw was blockchain meeting capital markets. tZERO, the trade is the settlement. Wouldn't it be great if we could issue trades, settle and clear same day without that central counterparty like DTCC, for example? And so the endeavor was really to move forward with the first public issuance of a blockchain security. And so tZERO undertook a number of acquisitions. So one of the first acquisitions was acquiring Pro Securities, an SEC registered and FINRA member broker-dealer approved as an alternative trading system. It was one of the first, if not the first, ATSs to file a Form ATS explaining to the SEC the matching of buying and sell orders of digital assets. That ATS was followed by an S3 registration filing in July of 2015. And that was really just putting the SEC on notice that Overstock would like to issue their shares in digital form. That was a 6-month Q&A process. Steve and his partners at Jones Day representing us and back and forth with a comment period just describing process flows, technology integration, a number of different registrants. That S3 was deemed effective in December of 2015. after that, it really then undertook an educational roadshow really with FINRA staff. And so together, Steve and I really, from Rockville, Maryland to Washington, D.C., multiple meetings and offices in New York, all the way out to District 2 in L.A., it was really just opening up a dialogue and explaining really the integration of technology, the process flows, the different registrants, or each with their own books and records requirements, which culminated really in joint meetings eventually with the SEC and FINRA, where we'd sit at a table with 30 people explaining what we wanted to do. All of that came to fruition really in December of 2016, when Overstock actually was able to issue their shares in digital form. There was an introducing broker, a clearing broker, we had a transfer agent, we had our Pro Securities as an ATS, and we issued, traded, settled, and cleared OSTKP, preferred shares in digital form. We did that same day, and we did that without having DTCC in the middle of that trade. That was really a Chuck Yeager moment in that to work with the regulators to integrate the technology and the tZERO suite of technologies with those different registrants, it became the first, certainly, of that kind of issuance and trading. Followed by 2017 with the advent of ICOs. So certainly as one application, right, initial coin offerings. Largely they started as utility token offerings. I think we all know that upwards of $2 billion is raised through ICOs through the summer of 2017 with little or no guidance really from, federal regulators. Well, that changed on July 25th of 2017 with the DAO report. And so that report was really a pivotal moment in the token space, if you will. It really, three things. On a facts and circumstances basis, federal security laws were certainly applicable. And then it said two things, right? Two more things. The issuance must be in compliance with federal security laws, so whether it be full registration, crowdfunding, Reg A+, Reg D, Reg S. And then, interestingly, the secondary trading can only occur in one of two ways, as outlined in the report. One is on a national securities exchange, of which today there is none, but I will get to that in a moment in our joint venture with Box, which addressing that. And the second, though, is listed as an exemption regulation ATS. So it really dovetails back to, in March of 2015, the acquisition of Pro Securities and the use of that ATS in Overstock's public issuance, where that ATS, matching the buy and sellers of digital assets, became really the first to do that. But here it is in the SEC report. And what followed from there really is not only a renewed interest in really the vision that tZERO brought to the marketplace and Patrick individually, but then we undertook our own security token offering. So we did a concurrent Reg D, Reg S offering. And so, with a very detailed private placement memorandum, white paper, and ad, certainly trying to set the standard of what a security token offering in our mind should look like. We culminated that in August of this year. We raised $104 million in cash, selling $134 million worth of tokens. And now, most recently, as you pointed out, this week we actually issued our tokens. And so we've started a clock of when those tokens will be freely tradable. That all ties into our efforts with Box. Box is a subsidiary really of the former Boston Options Exchange. That's a national securities exchange. And our vision was we have a joint venture, and so we are partners with Box Digital Markets as a subsidiary of that exchange. We have been meeting with the SEC. The entity of the joint venture is called TokenX, and the idea there would be the first national exchange for security tokens. And so we've been working on a rule book. We've been obviously working with the SEC staff on going over the technology and what the ultimate rule book for security tokens would look like. We think that puts us in a unique position, really the first ones to do that and to open up that dialogue with the SEC. And unlike others who who have also went in the ATS route. And ATS is open access, and certainly broker-dealer subscribers to an ATS. But what the National Exchange, what that will enable us to do is also set listing standards, listing fees, the dissemination of market data. So it's a different level, and the regulation, we believe, at the SEC level, will also attract that institutional investor that may be sitting on the sidelines waiting for that higher level regulated marketplace.
Thank you, Ralph. Let me turn to Kristen, who's got a lot of experience particularly on the issuer side. Based on your interactions with regulators and with your clients, what are the major concerns with respect to issuance and secondary trading of digital assets?
Well, it really seems to come down to the same issues that they've been dealing with, which it's the rule book. So they want to know, will your tokens be stored in a wallet? What's the security for that wallet? The SEC is not used to having the possibility of someone stealing your shares unless you go back to 1950 when you got paper that you stored in your banker's vault. So they want to know, how secure will it be and how will it be traded? And of course, when you're talking about Reg A+, which technically isn't a publicly traded company, but it is, they want to know how you'll protect against the usual things you see with publicly traded companies, where you have misuse of the markets, and of course, AML, KYC, which they're concerned about, but frankly, I think there are a lot of fantastic vendors, including some here, who can provide comfort to the SEC that will be handled.
Marc, let me turn it over to you. What are you seeing in terms of guidance out there from the regulators, particularly SEC guidance, and what do you think, really, with respect to the broker-dealer side of the business, what are you seeing as the primary issues and obstacles?
Sure. So I think the first, just to set the stage, is Ralph pointed out that they've been in front of the SEC for a long time. So the general idea that people had, especially last year, that the SEC is kind of getting up to speed on this stuff, tZERO did the job for everybody, and so they've been up to speed. The harder part for them has been figuring out, okay, so now that we have this information, how are we going to handle this industry, and how are we going to apply our rules to this industry? And obviously we know with respect to security tokens how that's going to be handled. But one of the ways in which they've been doing that, and FINRA's been doing it hand in hand with the SEC, is going, first of all, bringing enforcement actions against issuers and investigating them. And there's reports in February about the investigations into SAFTs, and frankly, there's reports out there about hundreds of issuers being investigated right now. But the interesting part is it's not just utility tokens that the SEC and FINRA is really not focused on the utility tokens, but the SEC is focused on. It's also the security tokens. And so you've got broker-dealers out there, some of which are in the room with us, who are going out to market offerings, and the SEC and FINRA are looking over their shoulder to see what they're doing with security token offerings. Now, the interesting part about that is if you look fundamentally at what many of these security token offerings are, and you look at how they work, it's simply an equity offering. It doesn't have to be. Token can represent anything. But many of them are just equity offerings. And it's really interesting. And you then take that equity, and instead of having an Excel spreadsheet or a written document that has a stock ledger, your stock ledger is on the blockchain. And it's really interesting that the SEC and FINRA are taking such a close look at things that people have done for dozens and dozens of years. It's just private placements. But now they're very interested in understanding especially how are you going to trade that in the secondary market? What are the broker-dealers doing to make sure that investors are being protected? And that's why you're kind of hearing a lot about, even in the security token space, investigations and audit types from the SEC and FINRA.
Marc, you raise a good point, if I could just jump in on that. Many of the processes that exist have been decades old, so the staff that were involved in setting up those processes are gone. So the new staff, thinking that something revolutionary is occurring, hasn't really understood what the actual processes are that are in place in order to grasp that. So from our client perspective with tZERO, there was like a double education that was going on. What were the current processes and the use of paper and Excel spreadsheets, and how do you revolutionize that with the new processes?
Steve, just staying on the regulatory theme for a minute, recently the New York Attorney General's office referred over 3 possible cryptocurrency investigations to the Department of Financial Services in New York for potential legal action based on market manipulation, potential conflicts of interest. How significant do you think that is? And overall, what are you seeing, not just on the federal regulatory side, but in the state actors as well?
So this is an interesting development because without a clear regulatory scheme, we have any number of players that want to jump in. And for many regulators and states, the idea of getting fines and sanctions gets applied to the budget. So there's, a perverse economic incentive for state regulation to take effect. New York's AG has been historically very aggressive in terms of policing securities and financial markets. New York has a very broad statute called the Martin Act that provides both civil and criminal penalties. And the New York State Department of Financial Services has been quite active in the virtual currency space. I think you probably have heard of New York's BIT license requirement and the Gemini exchange having certain New York State licenses in which to operate. Interestingly, with the Martin Act, there are very interesting tweaks in terms of the mens rea and the standards that apply for the criminal conduct. It's a very broad act that has broad applications. Things that we saw in the report that the AG was concerned about are, custody protections for customers and how funds can be audited, which is a unique problem in the cryptocurrency world. The types of trading activity that occurs, spoofing has been something that federal regulators have been very concerned about, the actual methodology of placing trades and canceling orders to inject basically false information into the marketplace as to whether there's more of a buy or sell at various price points. If that starts to be regulated by the 50 states, you'll have just chaos because there will be no standards that will be applied throughout. And then I think the final thing that the report really focuses on is whether participants in the area are acting as unregistered broker-dealers. And we know from press reports that the SEC has been very concerned about that activity with regard to not only technology companies, but folks who have been raising capital in terms of ICOs and other capital raises, and the intermediaries and the finders and how money is actually being raised in the technology industry is posing unique challenges for the regulators.
Marc, just in terms of the guidance that the SEC's put out there, particularly on the issue of whether digital assets constitute an investment contract, there was obviously a speech in June of this year from Bill Hinman, but what are you seeing right now in terms of that issue and the evolution of it?
Yeah. So, as former Chairman Cox mentioned earlier, I think it was a couple months ago, Bill Hinman, the chairman of the SEC, had this speech where essentially the term was used and everyone talked about it, which is, hey, if you're sufficiently decentralized, and then they gave a lot of guidance on what sufficiently decentralized might look like, then maybe your token is not considered to be a security. Maybe it was before, and maybe it's not now. And it's been really interesting since that guidance, and I think that's the point that everybody's looking at right now is what do we do with that? And I think there's quite a clear split in terms of whether that's something that's real or not. There's questions in terms of what the press release from the SEC in terms of, hey, don't necessarily listen to what the staff is saying. Was that really targeted at what Director Hinman said or not? But generally speaking, like I said, it's a split that you've got in the industry is can you have a technology and a community that's sufficiently decentralized so that your tokens are not considered to be investment contracts, or can you not? And I think the key part to look at that is really a question of take a typical commodity, I mean, let's take gold, and what drives, gold prices. And there's cases on this in terms of what constitutes an investment contract in the context of certain commodities. And generally speaking, you would say that the market, supply and demand, drives the price of gold. Now, when you look at Ether, you got to look, well, the Ethereum Foundation, is that driving the price of Ether? Or is it the hundreds of thousands of developers that are developing on it and the network effect that comes from that is now driving the price of Ether? And then again, so that's the analysis that Bill Hillman came up with. And the question is, do you agree with that or do you not? And we're really going to find out because right now it's not clear.
Kristen, on the issuer side, any particular thorny issues that clients, practitioners should be aware of on Reg A Plus offerings?
Oh, sure. The primary one really is, the SEC hasn't cleared any of these Reg A Plus token offerings yet. One of the approaches we're taking is actually to let the SEC know that they want to tokenize, but they don't want to hold up their offering while they wait for that. So they plan to issue using, one of the more traditional methods of keeping track of who owns the stock with the intention to tokenize the stock, issue it in token form. Once some of these other vendors are up and running. Another big point, of course, is so long as there's no secondary trading market for A+ tokens, if you conduct an offering with the hoopla of A+, that you'll be able to trade your tokens, your stock, you really can't right now because there's not much of a market. But and then aside from that, I think one of the keys to getting through the SEC would be to work with credible vendors so that they're somewhat familiar with the way you're solving for the problems that they're concerned about. They're concerned about the KYC, the AML. How are you going to keep restricted stock, for instance, out of the hands of your retail investors? And how will you prevent manipulation? How will you handle controls and compliance? That's a big one. Right now, like the SEC issued yesterday a report, an investigative report of the failure of some publicly traded companies to prevent phishing, where, for instance, a VP would send a message to an accountant in the firm and say, send $30 million by wire to this company elsewhere. And the accountant fell for the scam, and companies, all told, I think it's 9 companies, lost $140 million through these phishing scams. And the SEC found that they're not doing an enforcement action, but it was sort of a threat of companies need to have adequate controls and compliance in place, and of course then the auditors need to add this to their list of things they're checking for. So then you take that the next step to cryptocurrency, or to token securities, and how are the auditors going to evaluate your controls and compliance for that? And of course, that's where I recommend people work with really credible third parties rather than trying to manage that internally. That does take some of the fun out of tokens. Obviously we're losing some of the decentralization. When you start to really talk about token securities, you've got to bring in all of these different layers that traditionally have existed in the market. My personal approach is to try to work with things in a way the SEC understands so that businesses can do their business and continue to move forward, and then they'll be in a position to quickly change course as soon as the SEC is ready, as soon as folks like tZERO have paved the way for the rest of us. So.
Final question for Ralph is based on the successful token issuance this week. Is tZERO going to be hosting an open bar for lunch today?
Sure. Frank, I think, is in the audience, and he'll pick up the tab.
Anyway.
So thank you.
Thank you very
Thank
much
you,
to our
Dan.
panelists.
Okay.
Yeah.
Thank you, guys.